The first part of the contract section, section 3, we looked at the whole idea of a contract, what constitutes a contract, and these sorts of things. Throughout that section, we talked about how government had stepped in and made sets of rules or legislation that would effectively plug holes in contracts that were holy. Not all contracts are well put together. Not all contracts are complete. This leads to problems, and it has clogged up the legal system because of those problems. What government has tried to do is to say, okay, one of the solutions we can do is to impose rules on contracts that can be overridden by the contract. So, for example, the contract covered all the bases and was a whole, complete, proper contract. Great. What the government wanted to do was to plug in pieces of legislation in the event that the contract was not whole, that it missed certain parts, or it was unclear, or it was ambiguous, or these sorts of things. So essentially, there is a bunch of legislation that does this. And the reason, and the problem or the challenge with this is a little bit strange, because contracts, by the virtue that they are between a couple of people or a couple of parties or a business and a business, are private affairs. They are, by definition, just between two individuals. So the real philosophical question here is, if contracts are private, what's government doing involved in them? Well, the fact of the matter is the court system is public. And if contractors end up in our court system and clog it up, the taxpayer is effectively paying for their mistakes. So government has said we have a duty and obligation to minimize risk to taxpayers by reducing the number of potential problems that can exist from ill-defined contracts. So the biggest and most important piece of legislation that we are looking at in this course relative to contracts is something called the Sale of Goods Act. And the Sale of Goods Act exists at the provincial level, so that means that there's 13 copies of this across the nation. And it steps into contracts when contracts are vague. Okay, the whole idea, it is designed to plug holes in contracts. Now, there are lots of Sale of Goods Act across Canada. Every province has their own Sale of Goods Act, and the federal government has a Sale of Goods Act as well. We're in Newfoundland. I'm going to focus on the Newfoundland Sale of Goods Act. They're all relative copies of one another, okay? They're all relative copies, and the concepts are identical. So instead of super confusing it, we're only going to look at the Newfoundland, the Newfoundland Sale. The number one item that's goods. It does not cover services. Okay. What we're trying to do with the Sale of Goods Act, the primary function of it is to establish who owns the product at any given point in time. So we've got this issue of title, who owns it, and the issue that emanates from that, risk. So if I sell you my car, and we're about to do the deal. I'm about to hand you the keys. So here I am handing you the keys, and poof, a giant meteor crashes from space, just landed on the car and destroyed the car. Okay? Who owns the car at that point in time? That's the question. Who owns it, and who then is going to suffer the loss of it? If you've handed me the money for the car and I'm about to hand you the keys, what is the loss and who is the loss associated with? And that's really what the Sale of Goods Act tries to do, is to kind of plug that big hole, because that's been a problem with some of these goods. We're going to review the obligations of the seller, review the consumer protection legislation that's out there that kind of looks at some of these issues related to risk. And we're going to look at a little bit at federal legislation. Now, what I mean by federal legislation is that there is, according to the Constitution, the original B&A Act and the Constitution Act 1982, The original Constitution, or the Constitution, lays out what parts of government are the responsibility of what government. So the federal government has allocations for responsibility for certain things, and the provinces have allocation of responsibilities for everything else. If it's silent, then it ends up in court. And we've had a lot of cases over the last 153 years of Canadian history as to who's responsible for this. Is it a federal jurisdiction or a provincial jurisdiction? Well, over the course of time, the following items, from a point of view of sale of goods, have been determined to be, either through the fact that it's clearly indicated in the Constitution or through court action that's been clearly told in the Constitution. The federal government is responsible for legislation involving competition, deception of selling deception, securities, which is like banknotes and the like, and bankruptcy and insolvency. So those things are covered under federal legislation. So the Sale of Goods Act is provincial legislation. When does someone cease owning something and begin owning something? When is that transition period between the sale of a product and the risk? So the title and the risk are the big issues. So if the object gets destroyed in the process of the contract, who bears the loss? Okay, and that's been a real challenge for a lot, because we have a lot of issues with that. So the Sale of Goods Act is really designed to help define who owns a product and when. The situation with the Sale of Goods Act is it just focuses on hard items. It does not cover items that are covered by other pieces of legislation, such as property and the like. And it also does not cover services. So it is just for hard products that are movable, tangible items. So the Sale of Goods Act is, as I say, a piece of provincial legislation, but it's been around and it gets updated every once in a while, and you can see the level of updates that are there. It has 6 or 7 parts to it. The first 3 parts are the most critical parts. Part 1 deals with the formation of a contract, and what we need to be aware of is, what does the Act say in terms of what it takes to make a contract? So a contract of sale of goods is a contract by which the seller transfers or agrees to transfer the property in goods to the buyer for money called the price. Now that seems pretty straightforward, but it does clarify the fact that it is a transfer of an agreed set of goods for some consideration known as the price. The contract, there may be a contract of sale between one part owner and another. A contract of sale may be absolute or conditional. So I will sell you my computer mouse, this computer mouse right here, for $1. That's an absolute contract. We have a clear idea of what the product is and what the price is. Or it could be conditional. I will sell you my computer mouse for $1, but I will have to put a new battery in it first. Okay, so that's what we mean by conditional contract. Some condition has to be met in order to make the contract whole. Or 4, we're under a contract of sale. The property in the goods is transferred from the seller to the buyer. The contract is called a sale, by where the transfer of the property in the goods is to take place at a future time or subject to a condition to be fulfilled at a later time. The contract is called an agreement to sell. So effectively, and we looked at this in the legislation, that not all goods are going to be sold instantly. So I will sell you my computer mouse next month once I replace the battery, okay, for $1. That sort of thing. And 5, an agreement to sell becomes a sale when the time elapses, the conditions are fulfilled, subject to which the property of goods is to be transferred. Okay, in this particular instance, we have to find out when transfer happens, and transfer can happen by, I'll call it the passage of time. You own a store, I come into you and I say, I'd like to buy these pants, but I really need to try them on first. I bring them home to try them on. I don't bring them back to you. So what are you to assume? That I've accepted them? or that I haven't bothered to try them on, or I'm going to bring them back. Well, there comes a point in time where you're going to have to say, well, Paul hasn't brought them back, so the contract must be done. There is a reasonable, what if we brought them back in a year? What if we brought them back in 2 years? What is the point? So it really covers that issue with regards to time goes by, and by my actions, the contract is complete. We also introduce a concept called capacity in here. And capacity is to buy and sell is regulated by the general law concerning capacity contract, and we've discussed that already in the previous section, where you have to be, a majority, you have to be a sound mind. These sorts of things come into play in order to allow a transfer to take place. Where necessities are sold or delivered to an infant or minor, or a person who, because of mental incapacity or impairment by alcohol or drugs, is incompetent to contract, he or she shall pay a reasonable price for these necessities. And we already talked about that. The fact that you can bind a minor or bind someone who has incapacity issues if you were to sell them necessities, okay? And or necessaries, as we call them in this particular piece of legislation. Necessaries in this section mean goods suitable to the condition in life of an infant or minor or other person, and to his or her actual requirements at the time of sale or delivery. So it defines what necessity is. In terms of form of contract, a contract of sale may be in writing, either with or without a seal, or by word of mouth, or partly in writing, partly by word of mouth, or it may be implied from the conduct of the parties. So this just effectively means that it can be in writing, it can be in a verbal agreement. If there's no consideration, the seal issue takes, you can put a seal on it, and it doesn't require consideration. And the other thing is the implied contract. That is, I went and I got a pair of pants off you, I didn't bring them back, I've had them for 2 weeks, you're going to imply that I have purchased them. And nothing in this law shall affect the law retaining corporations. In other words, it's not going to override other laws. Now, here's something we haven't looked at yesterday, and that is a contract of sale of goods, a value of $50 or more, shall not be enforceable by actions unless. Okay? So this is a $50 limit here. So a contract of sale of goods of value of $50 or more shall not be enforceable by actions unless the buyer accepts the actual received part of the goods sold, the buyer gives something in earnest to bind the contract consideration, some written note or memorandum of sale is made. This section applies to contracts referred to in subsection 1, notwithstanding the goods are maybe intended for delivery at a future time. Goods may not at the time of contract be actually made. We talked about that. The goods may not at the time of contract be fit or ready for delivery. And so essentially what this is saying is once it goes over $50, we really need something to well, the writing thing is really something to really make the contract clearly enforceable, okay? You need to be able to demonstrate all of these ABCD functions. Okay. Goods as subject of contract. So this is just a clarification of what is it you're actually selling, right? The goods which form the subject of the contract of sale may be existing goods owned or possessed by the seller, or goods to be manufactured or acquired by the seller after the making of the sale contract. These are called future goods. We've talked about those last. There may be a contract of sale of goods, the acquisition of which by the seller depends on a contingency which may or may not happen. So we talked about the contingencies. I will buy it if you put a battery in it. Right? And the third one, whereby contract of sale, the seller purports to effect a present sale of future goods. The contract operates as an agreement to sell goods. So it's not truly a contract until it is made whole, meaning that we've agreed that at some future point to do something, but it is still an agreement to sell as opposed to a hard contract. So we've also talked about this in our preliminary too. This next section, which looks at loss of the specific goods. So where there's a contract for the sale of specific goods, and the goods without the knowledge of the seller have perished at the time when the contract is made, the contract is void. So effectively, if the goods get destroyed, something happens to them, there is no contract. So if there was a loss of specific goods after an agreement to sell, and remember now an agreement to sell is I'm going to sell them to you later, where there's an agreement to sell specific goods and later the goods without fault of part of the seller or the buyer perish before the risk before the risk passes to the buyer, agreement is void. So effectively, if there's agreement to sell and the things fall apart, blueberries go bad or whatever, there is no contract. So the risk stays with the person who owns them to start with. The price of the goods, and again, this plugs in where price is not necessarily clearly. The price in the contract of sale may be fixed by the contract or may be left to be fixed in a manner agreed upon in the contract. So for example, if you're selling it by weight, I'll pay you $10 a pound for blueberries. So that is determined there. Where the price is not determined under subsection 1, the buyer shall pay a reasonable price. Well, what we define as reasonable could be questionable. In this section, a reasonable price in question of fact dependent on the circumstances of the particular case. So in other words, that price is really dependent on the actual case, and someone's going to have to come in and determine what is reasonable. So the someone coming in to determine what is reasonable is covered in the next section, which is the third-party valuation. Whereas an agreement to sell goods on the term that the price is to be fixed by the valuation of a third party, and that third party cannot or does not make the valuation, the agreement is void. So if you don't have someone come in and value it, there's no contract. Where the goods or part of the goods have been delivered to an appropriated by the buyer under section 1, he or she shall pay a reasonable price. Again, basically saying if you got it or you got part of it, you're going to pay a reasonable price for it. Where the third party is prevented from making the valuation by the fault of the seller or the buyer, the party not in fault may maintain an action for damages against the party at fault. So again, if someone doesn't do it, where the third party is prevented from making the valuation, and it's prevented by the seller, so effectively you agree that someone's going to come in and value it, the seller prevents that person from doing it, then there can be damages that can be actioned. Time, and this question of time is a questionable thing in a contract, particularly for future sales. So unless a different intention appears from the term of the contract, stipulations as to the time of payment are not considered to be the essence of the contract of sale. So again, the contract can take place without having time specified. Where another stipulation as to time is of the essence of the contract depends on the term of the contract. Whether another stipulation as to time is of the essence of the contract depends on the terms of the contract. There could be other things in there. So for example, snowblower by winter. Well, we haven't specified a time, but we have specified winter. In a contract of sale, month means a calendar month. And again, that's more legalese. If there was a condition in the contract, I will sell you my computer mouse. You say to me, well, provided that you put a new battery in it. So 13 says, where a contract of sale is subject to a condition that is fulfilled by the seller, a buyer may waive the condition or may elect to treat the breach of condition as a breach of warranty and not as a ground for treating the contract as repudiated. So let's assume we have the contract to sell you my computer mouse. You said to me you needed a battery in it. I don't put a battery in it. Well, you have a choice there. You can treat that breach as a warranty, meaning that I will replace the battery after you buy it, or or I could say, yeah, I'll accept it as it is, or you'll accept it as it is. So we don't need to erase the contract because one of those conditions. It's up to the buyers involved. Whether a stipulation in a contract of sale is a condition, the breach of which may give rise to the right to treat the contract as repudiated, or a warranty, the breach of which may give rise to a claim for damages, but not a right to reject the goods and treat the contract as repudiated, depending on each case on the construction of the contract. Well, this is you can drive truck through this, but effectively what this says is, look, a condition has been breached. You can treat the contract as repudiated. So you can say, oh, forget it, we're not going to do it. Or you can treat it as a warranty. And you can seek damages. A stipulation may be a condition through, though called a warranty in the contract. So it could be the concept of a warranty. A warranty is after the fact, we agree to the contract, and after the fact, I'll fix it. Okay, so that's effectively what a warranty is. Repudiation or condition is, I'm not going to do the contract unless you do that. So they're slightly different. Where a contract of sale is not severable, and the buyer has accepted the goods or a part of the goods, or where the contract is for specific goods, the property in which has passed to the buyer, the breach of condition to be fulfilled by the seller can only be treated as a breach of warranty, not as a ground for rejecting the goods and treating the contract as repudiated unless there's a term in the contract that implies that effect. Okay, what does this mean? We got this word severable in here. Severable means that what you're selling is a bunch of things. Okay, so let's assume that I sold you all of the contents of my shed. Okay, so whatever that is, you don't know, well, you don't need to know what's in my shed, but I sell you the whole contents of my shed, and you find out that you didn't get the whole contents of the shed. One of the important parts were missing. Well, the question is it what's called a severable contract? And a severable contract means that it doesn't all have to be fulfilled. So let's say there's 10 items in a shed and you got 9 of them. That's a severable contract if the contract can still proceed if 9 out of the 10 items is adequate. Unless it says in the contract I need all the items, it could be severed, and the price could be set accordingly. And again, you would have right for action. So this breach of contract thing comes into play. We also have implied conditions and warranties. So in a contract of sale, unless the circumstances of the contract show a different intention, we can write it out of the contract, in other words. There is an implied condition on the part of the seller that the case of a sale, he or she has the right to sell the goods, and that the case of agreement to sell, he or she have the right to sell the goods at the time when the property is to pass. So you would assume in this case that I actually own the goods and can sell them, and that I can put a time on when they sell. An implied warranty that the buyer shall have and enjoy the quiet possession of the goods. So we talked about that the other day, and this is, you have to be able to use the goods without someone bugging you on it. So if the bank starts calling me next week, if you sell me a quad, and the bank starts calling me next week looking for the money for it, well, I paid for the quad. You didn't tell me that you owed money to the bank on it. So I'm not having quiet possession of the good. So effectively, we can erase the contract. An implied warranty that goods shall be free from a charge or encumbrance in favor of a third party. Again, same sort of thing, not declared or known by the buyer. So there is a lien on the machine, and effectively the bank is bugging me for it. That would mean that I'd get my money back and you'd get the quad back, and you'd have to deal with it. We also talked yesterday about this idea of sample. You buy 100 pounds of blueberries from me based on a 2-liter container that I have, and you're looking at my 2-liter container of blueberries and saying, well, they look good. So you agree to buy 100 kilograms of blueberries from me based on looking on the sample. Okay, that's effectively, or maybe we're selling material and I show you a little swatch of material and you buy a whole load of material based on the swatch. So this is what we mean by a description by sample. Where's a contract for sale of goods by description? There's an implied condition that the goods shall correspond with the description. So if I sell you blueberries based on that sample, the blueberries I sell you better look like that sample. And if I sell you a material based on a swatch, the material better look like that sample. If it's not, then the contract can be eliminated. And where the sale is by sample as well as description, if it is not sufficient that the bulk of the goods correspond to the sample, or the goods do not correspond with the description. So we got this sample and description here. It is not sufficient that the bulk of the goods corresponds with the sample, where the goods do not also correspond with the description. So I describe my blueberries as tasty and fresh. Even though they're blueberries that I give you, they're not tasty and fresh. So that would effectively void. So we've got a whole section there on section 16, which is really dealing with condition and fitness. Again, same sort of thing. There's no implied warranty or condition as to the quality or the fitness of a particular purchase of goods supplied under contract of sale, except as follows. And you have a bunch of conditions there that basically lay out what the defined condition needs to be. A, where a buyer expressly or by implication makes known to the seller that particular purpose for which the goods are required, so as to show that the buyer relies on the seller's skill or judgment, and that the goods are of a description which is in the course of the seller's business to supply, whether he or she is the manufacturer or not. There's an implied condition that the goods shall be reasonably fit for the purpose. So if you're selling plumbing supplies and I come to you and I say, well, I need a plumbing supply from you that will allow to take a water pressure of 150 PSI, okay? And you say, yeah, that will do. But effectively, what you sell me doesn't do. It's not fit for the pressures that's involved. Then the product is not satisfactory and it does not meet my requirements, and as a result I can seek redress for that. In the case of a contract of sale for a specific article under its patent or other trade name, it is not there is no implied condition as to the fitness of the particular purpose. So again, if I'm looking for a specific process, I want a rigid pipe, rigid being a brand name. So in the condition of contract of sale for a specific article under its patent or other trade name, there is no implied condition as to the fitness for a particular purpose. So I'm assuming that the rigid pipe does not have a hard condition to it. C, where goods are bought by description from a seller who deals in goods of that description, where he or she is a manufacturer or not, there's an implied condition that the goods shall be of merchantable quality. And again, effectively, it's the exact same thing where we need to say, does this product meet the requirement of what I'm asking? D, where the buyer has examined the goods, there shall be no implied condition as regards to defects which the examination ought to be revealed. Okay, so the buyer has examined the goods. There shall be no implied condition as regards to defects which the examination should ought to have revealed. So you're buying it, you've had an opportunity to look at it, and so you should be able to tell if the product is bad at that point in time. E, an implied warranty or condition as to quality or fitness of a particular purpose may be annexed by the usage of trade. So an implied warranty condition as to quality or fitness for a particular purpose may be annexed by the usage of trade. So this could be, I don't know, some sort of a plumbing pipe that's used in the plumbing purposes. It may have a defined use for it in the trade. An express warranty or condition does not negative a warranty or condition implied by the act unless it is inconsistent with the act. In other words, it has to fit the act as long as it's not inconsistent. 17, contract of sale is a contract by sale by sample where there's a term on the contract express or implied to the effect. So a contract of sale is a contract of sale by sample, where there is a term of the contract express or implied to the effect. In the case of the contract for sale of sample, there's an implied condition that the bulk shall correspond to the sample quality. The buyer shall have reasonable opportunity to compare the bulk with the sample, and the goods shall be free of defect. So again, that just makes sense that you can review the quality of it. So that first section is really just an overall of what the Sale of Goods Act is supposed to do. The second section looks at the effects of the contract. So where's the contract of sale for unascertained, in other words, undefined goods, a computer mouse, as opposed to this computer mouse. Property goods is not transferred to the buyer until the goods are ascertained. Okay, so you need, the transfer has to be clear on what you're buying. Okay, it has to be crystal clear. So the transfer requires that. Where there's a contract to sale for specific or ascertained goods, the property in them is transferred to the buyer at the time when the parties of the contract intend to be transferred. So I'm going to give it to you tomorrow. That's the time. For the purposes of ascertaining the intention of the parties regard shall be had to the terms of the contract, the conduct of the parties, and the circumstances of the case. So our actions are going to help imply when that transfer. This section 20 is what we discussed yesterday with regards to the title transfer and the 5 rules of title transfer. So this is exactly the same thing. Unless a different intention appears, the following are rules for asserting the intention of the parties at the time at which the property goods pass to the buyer. Okay, so what we got here is a very clear set of rules, but those set of rules only apply unless there was a different intention in the contract. So effectively, you can write the contract to override these rules. So we looked at these rules the other day, and these rules, just to paraphrase them, Rule 1 says, look, if we got a contract and to sell this computer mouse, so it's unconditional, there's no conditions on it, it's a deliverable state, it works, so the property, the goods, passes to the buyer when the contract is made, and it's immaterial whether the time of the payment and the time of delivery or both is postponed. So effectively, if we agree, I'll sell you my mouse, you say, okay, $1, the deal is done. So Rule 2 is where there's contract to sale for specific goods and the seller is bound to do something with the goods for the purpose of putting them in deliverable state. I got to put a battery in the mouse. The product doesn't transfer until I give you notice that I put a new battery in. Okay. Rule 3, where there's contract to sale for specific goods and deliverable state by the seller, but I'm bound to weigh it, measure it, do something with it. I have to test it or whatever. Then I have to do the testing first before, and then I alert you that testing is done, and then it transfers. Rule 4, where the goods are delivered to the buyer on approval or on sale or return or other similar terms, the property in these goods passes to the buyer, A, when the buyer signifies his approval or acceptance of the goods to the seller, or when the buyer does not signify his approval or acceptance to the seller, but retains the goods without giving notice of rejection. So I go buy that pair of pants from you at the store, I bring them home, I say I'm going to try them on, I don't bring them back to you, you got to assume that I bought them. So I didn't give you any notice of rejection, and so the deal is done after a set time, expiration of a reasonable length of time. And Rule 5, where's a contract to sale for unascertained or future goods by description, the goods of that description and in the deliverable state are unconditionally appropriated to the contract either by the seller with the assent of the buyer or the buyer with the assent of the seller. The property and the goods at the time passes to the buyer. So we need to be able to figure out when we're actually going to sell these future goods. We can put a time on it. And it says the assent may be expressed or implied. So these are critical. Those 5 rules are really critical to determine when the transfer occurs. Okay. And we also have the right of disposal of goods and that is, okay, I've got all these blueberries picked for you, waiting for you to pick them up. You haven't picked them up. So where's a contract to sale for specific goods, or where the goods are later appropriated to a contract, the seller may, by the terms of the contract or appropriation, reserve the right to dispose of the goods under certain conditions, until certain conditions are fulfilled. So in the case under section 1, notwithstanding delivery of the goods to the buyer or to a carrier or other bailee for the purposes of transmission to the buyer, the property in the goods does not pass to the buyer until the conditions imposed by the seller are fulfilled. So we could have some conditions that say you need to do this, this, and this, so it doesn't transfer until that, and that is done. Where the goods are shipped or by bill of lading, the goods are deliverable to the order of the seller or his or her agent. The seller is, in the absence of evidence to the contrary, considered to reserve the right of disposal. So if we haven't got it clear, we can dispose of it. Where the seller or of the goods draws on the buyer for where the seller of the goods draws on the buyer for the price and transmits a bill of exchange and a bill of lading to the buyer together to secure acceptance of payment of bill of exchange, the buyer is bound to return the bill of lading where he or she does not honor the bill of exchange. So you need to inform them if you're not going to accept it. Goods at seller's risk. So this section 22 again talks about the risk issue. Unless otherwise agreed, goods remain the seller's risk until the property is transferred to the buyer. When the property in the goods is transferred to the buyer, the goods are in the buyer's risk whether delivery has been made or not. So we don't need delivery. Where the delivery has been delayed through the fault of either the buyer or seller, the goods are at the risk of the party in default as regards to the loss, which may or may not have occurred, but for that fault. So if I delayed sending you my mouse and the mouse got broken in the meantime, the risk is with me. If you prevented me from sending you the mouse, the risk is with you. Okay. And again, it goes on to say about nothing in this shall affect the duties or liabilities of either seller or buyer as the bailee of the goods or other party. At section 23, the buyer acquires no better title than the seller. Where goods are sold by a person who is not the owner of the goods and who does not sell them under the authority or the consent of the owner, the buyer acquires no better title to the goods than the seller had, unless the owner of the goods is, by his or her conduct, precluded from denying the seller's authority to sell. Okay, so we got a situation here is where the goods are sold by a person, someone sells them, but they don't actually own the goods. So I'm selling you the car across the street, not mine, but I'm selling it to. The buyer acquires no better title to the goods than the seller had. So effectively, I can't sell you that car across the street because I don't have title to it, and you don't get any title to it too, even though you agreed to it. So this is a good one for someone who sells stuff that they don't own, stolen goods. There's something called a saving provision too, 24. Nothing in this act shall affect an enactment enabling an apparent owner of the goods to dispose of them if he or she were the true owner of the goods. So basically, you can throw it out. The validity of the contract of sale under a special common law or statutory power of sale or under the order of the court of competent jurisdiction. So nothing in this act shall override a court decision effectively. Section 25 deals with the seller's title. Where the seller of the good has a voidable title to the goods, but his or her title has not been avoided at the time of the sale, the buyer acquires a good title in the goods. So if I bought a car from someone that strictly the contract could be voided, they haven't sent it to me yet, I can still sell that product because I am supposed to own it. And it goes on to talk about property and stolen goods, and effectively the court is not going to enforce any stolen goods. Where goods have been stolen and the offender is prosecuted to conviction, the property in the stolen goods revests in the person who was the owner of the goods to start with. Delivery of goods by person in possession to purchaser in good faith. Section 27, where a person having sold goods is in possession of the goods or documents of title to the goods, delivery or transfer by that person or by a mercantile agent acting for him or her of the goods or documents of title under the sale, pledge, or other disposition to a person receiving the goods in good faith without notice of previous sale shall have the same effect as if the person making the delivery or transfer were expressly authorized by the owner of the goods to make the transfer. This is where third parties come in. So I give it to someone to bring to, that sort of thing. Okay. And so that really covers that major section. Part 3 looks at the performance of the contract, and it really gets into how do we make the contract whole again. It's a duty of the seller to deliver the goods to the buyer, for example. Delivery and payment concurrent conditions. Unless otherwise agreed, delivery of the goods and the payment of the price are concurrent conditions. That is to say, the seller shall be ready and willing to give possession of the goods to the buyer in exchange for the price, or the buyer shall be ready and willing to pay for exchange of the goods. So this is just standard. You would think that that would make sense in a contract that we're going to swap. Repossession. How do we handle repossession? Whether it is for the buyer to take possession of the goods or for the seller to send them to the buyer, if that's in question, depending on the contract, expressed or implied between the parties, apart from a contract referring to this in subsection 1, express or implied, the place of delivery is the seller's place of business, where the seller has one, and if not, his or her residence. So, okay, where it's to be delivered, where the contract of sale of specific goods, which to the knowledge of the parties when the contract is made are in some other place, then that place shall be the place of delivery. In other words, you can have it delivered to another address, but everyone has to be clear on what that address is. Where under contract of sale, the seller is bound to sell the goods to the buyer by no time, but at no time for sending them is fixed, the seller is bound to send them within a reasonable time. So again, we need to send it within what's called a reasonable time, unless there's something fixed to say it got to be delivered in a week. Where the goods at the time of the sale are in the possession of a third person, there is no delivery by the seller to the buyer unless and until the third person acknowledges to the buyer that he or she holds the goods on his or her behalf. So again, someone's got it in storage somewhere. There is no delivery by the seller to the buyer unless and until the third person acknowledges to the buyer that he or she holds the goods. So that third person has to get involved there. Nothing in this section shall affect the operation and issue of transfer documents, title of goods. So effectively, we've got just kind of putting fine points on these types of things. Here in section 32, and again, it just says if we don't deliver the whole thing, if we're blueberries and I only sell you half, only send you half of them, where the seller delivers to the buyer a quantity of goods less than the seller contracted, the buyer may reject them. However, where the buyer accepts the goods delivered, he or she shall pay the appropriate amount. So if you got half the goods, you're responsible for paying half of them. Okay. Where the seller delivers to the buyer a quantity of goods larger than he or she contracted the seller, the buyer may accept the goods included in the contract and reject the rest, or the buyer may reject the whole. So you bought 100 pounds of blueberries, I sent you 200. Well, you can certainly reject the amount that's over 100, and you can actually reject a whole lot. So again, I can't force you to buy something that you didn't agree to buy. That's all that means. 3, where the buyer accepts the whole of the goods delivered under section 2, he or she shall pay for them at the contract rate. So if you accept all the blueberries, you need to pay me for all the blueberries at the contract rate. Where the seller delivers to the buyer the goods, the seller contract sell mixed with goods of different description, not including contract, the buyer may accept the goods which are in accordance with the contract and reject the rest. That don't make sense. I sell you blueberries, and I sent you blueberries and raspberries, you can reject the raspberries or reject the whole lot. Okay. And we can get delivery by installments as well, unless otherwise agreed. The buyer of the goods is not bound to accept the deliveries of those goods by installments. Where there's a contract of sale for goods to be delivered by stated installments, which are to be separately paid for, then the seller makes defective deliveries in respect to one of the installments, or the buyer neglects or refuses to take delivery of one of the installments. It is a question depending on the terms of the contract and the circumstances of the case, whether the breach of contract is reputable, if you can repudiate the contract. So effectively, I send you, we agreed I'm going to send you things in a batch of 4 batches. I send you 2, 3, 4 batches. 3 of the batches are good. The 4th one is no good. I can argue that the whole thing is breached. Okay. Delivery to the carrier, and this is what we talked about with regards to who pays and when does risk shift. We're under the contract of sale. The seller is authorized or required to send the goods to the buyer. Delivery of the goods to a carrier, whether named by the buyer or not, for the purpose of transmission to the buyer, is considered delivery of goods and goods to the buyer. Unless otherwise authorized by the buyer, seller shall make with the carrier on behalf of the buyer a reasonable contract having regard to the nature of the goods. Where the seller does not act as required under subsection 2 and the goods are lost or damaged in the course of transit, the buyer may decline to treat the delivery to the carrier as a delivery to himself or herself and may hold the seller responsible for the damages. That's self-evident. Unless otherwise agreed, where the goods are sent by the seller to the buyer by a route involving sea transit under circumstances in which is usual to ensure, the seller should give notice to the buyer which enables him or her to insure them during sea transit. And where the seller fails to do this, the goods shall be considered to be at his or her risk during the sea transit. So you got to alert people that it's being shipped and that they're responsible for insuring it. We got this issue of deterioration too, which can happen where the seller of the goods agrees to delivery them or his or her own risk or a place other than where they've been sold. The buyer shall, unless otherwise agreed, take the risk of deterioration in the goods necessary incident in the course of transit. This is a common problem in Newfoundland. We sell stuff, so you sell stuff to a store, let's say in Maine, and it gets damaged along the way, freezes, that sort of thing, and we run into some problems there. So where the seller of the goods agrees to delivery, okay, so I'm going to sell you goods, you're up in Maine, I agree to send them up the Maine, then we get this risk issue, okay. Right to examine the goods, and where the goods are delivered by the buyer, which he or she has not previously examined, the buyer is not considered to have accepted them until they get a reasonable opportunity to look at them. So again, no real deal there. The goods are considered accepted. The buyer is considered to have accepted the goods when the buyer intimates to the seller that he or she has accepted them. So I basically told you I've accepted them. The goods have been delivered to the buyer and he or she does not act in relation to them with, which is inconsistent with the ownership of the seller. I haven't given you any indication that I'm not going to accept them. That's what B is. After a lapse of reasonable time, the buyer doesn't indicate any problem, so she's good. Now, here's an interesting one too. This is if the buyer who rejects the goods, who's responsible for getting them back? So unless otherwise agreed, where the goods are delivered to the buyer and the buyer refuses to accept them, having the right to refuse, he or she is not bound to return them to the seller, but it is sufficient if the buyer intimates to the seller that he or she refuses to accept them. So it's not, if there's some reason that they reject them, not fit, deteriorate, they're not responsible for getting them back to you. There could be a wrongful refusal of delivery where the seller is ready and willing to deliver the goods and requests the buyer to take delivery, and the buyer does not within a reasonable time after a request to take delivery of the goods. He or she is liable to the seller for loss occasioned by his or her neglect or refusal to take delivery, and also for a reasonable charge for the care and custody. So I send you up something, you refuse to accept it. Otherwise, everything is good. I can seek you, be responsible for taking care of it and the cost of that. Nothing in this section shall affect the rights of the seller where there is neglect or refusal by the buyer to take delivery. So these are the fundamental sections of the Act, which kind of cover some of these holes that we've talked about. And I think those holes are important because a lot of contracts don't cover those finer points. So that's what the Sale of Goods Act is designed to do, is to kind of plug any holes that may show up in the contract which affects title and risk and the various obligations of the buyer and the seller. The Sale of Goods Act is a provincial piece of legislation for the purposes of what we're looking at. And as I said, the parties can override most of the provisions. If you put in the contract clearly stating that this is what happens if the goods are unfit, there's no reason for the Sale of Goods Act to apply to that particular case, because it says in the contract, right? It's only designed as a plug. It doesn't replace the contract. It replaces things that aren't in the contract. And there needs to be the actual sale, and it could be now or into the future. As I said to you, the Sale of Goods Act focuses most importantly on the fact that the good is a tangible piece of product, something that you can see and touch. And it has to be on movable property, because immovable property, or property that you can't move, is covered under other pieces of legislation. Okay, so a house, for example, is not considered a movable property, so it's covered under separate legislation. So normally this would be something that you could take and move from point A to point B. As I say, it doesn't apply to service contracts. Now, seeing that service contracts constitute about 60 to 70 to 80%, I suppose 60 to 80% of the products that are sold, Sale of the Goods Act doesn't cover that. It only has to be for raw product. Sometimes, and this is where it gets gray, we ask, well, is it service or is it a good? And you know that there's no such thing as a pure good. So if I go to buy a hamburger at McDonald's, you know, is the service part of it? The restaurant, the cooking, the delivering, is it a service or is it a product that I'm buying? Well, generally the Act says that the service has to be incidental to the transaction. So I'm buying a hamburger, that's the primary thing. The fact that there's these service components to it, it's incidental. It's not the full transaction. Okay, the number one issue that the Sale of Goods Act covers is the issue of title, and followed with the title is the idea of risk. So risk follows title. Okay, if you own it, you have the risk of it. If you don't own it, you don't have the risk of it. So that's what we mean by risk follows title. So, you know, the Act can be overwritten, as is the case with everything. The Act can be overwritten because if you've written it into the contract that, okay, in this case, if you got what's called a CIF, or cost insurance freight, the vendor must arrange transportation and insurance against risk. If it clearly says in your contract that the seller has to transport it and have the insurance against risk, then that specifies who's holding the risk of it, right? And so there's no need for the Act to take any input into that. Or another type of common delivery term that we use is free on board, or FOB. And there the parties specify in the contract where the title and where the risk falls. So we'll put it on, okay, if you're a producer producing it in Quebec, we could say that we're selling you this for $10,000 FOB Montreal. That means that that producer owns it right up until the point to put it on a ship in Montreal, and we'll put it free on board the ship, that is. But the buyer is responsible for insuring it along the way. So if, say, for example, you put it on an OceanX cargo ship in Montreal to be delivered to St. John's, and as the ship is sailing along the way, it sinks. Okay, so it loses the product. Well, who effectively suffers the loss? Well, the buyer of the product in this case would suffer the loss because it was FOB. So now what the buyer would do is go after the carrier and company's insurance would cover it. So for example, if OceanX sank, the boat sank, OceanX would cover the expense of the loss. The first time I've ever heard tell of FOB, actually going back to 1977, the William Carson was a ship that sailed between Port aux Basques and North Sydney for years and years and years. It was the first modern ferry that went across the Gulf because it could take cars. Anyway, the ship was built in the 50s, and in 1977 it was relegated to the Labrador crossing, or the Labrador, and it left Louisport, and it was sailing up on the 6th of June in 1977, and it hit an iceberg similar to the Titanic. It hit a small piece of ice. Anyway, it wasn't a big iceberg, but it did hit it. And up off the coast of St. Anthony, she basically sank. The William Carson sank. And she was full of new pickup trucks and beer. And anyway, you could hear the beer popping when she sank, and you could hear the trucks smashing. So there was a big story. I remember reading a story in the newspaper at the time about how much beer was lost and who basically would be compensated. CN had the insurance on all the beer and the trucks. Terranova Motors and St. John's and the Dominion Company got a bunch of money for losing their shipment. Another example of a way that you can determine who takes the risk is if COD is written on the package. And you don't really hear tell us COD anymore like you did, but COD stands for cash on delivery. So if the contract clearly lays out that it's cash on delivery, the risk and title don't pass until the receipt of the goods and the fact they're paid for. So again, it shows up in the post office, and what you had to do years ago is you had to pay for it at the post office. So your parcel would come, and it would be a COD package, and the parcel was worth $15. You had to pay $15 at the post office, and you get your package. Well, the moment you paid $15 and the package was handed to you, you now own it. Okay? Up until that point, it was the company's problem. It is common that all shipments will have what's called a bill of lading. And if you look at when you get something from Purlator, or if you get something from any of the companies, it will have a little bill in it. And that sheet of paper is normally called a bill of lading. It can be used to control the risk. So if the seller names self to receive the goods, he or she retains control of the goods, but also the risk. So if you ship it, say, to yourself, so if J1 Construction ships a truck from Corner Brook to Clarenville on a trucking company's float, effectively they're shipping it to themselves. Well, the bill of lading will indicate who owns it at what point. So normally then we run into some gray area when those sorts of things, be it COD or free on board, are not clearly laid out in the contract. And whenever you get this uncertainty, this is when the Sale of Goods Act kicks in, okay? So the Sale of Goods Act basically says, under certain provisions, we will assign who owns the product. So there's basically, I think there are 4, if I recall. There's 5. There's 5 basic rules that are discussed in the Sale of Goods Act with regards to who owns it when, if it's not specified in the contract, okay? Rule number 1 says if it's a specific identified good in a deliverable state. So it's a specific, it is this computer mouse. It is identified, it is a computer mouse, and it is deliverable. Yeah, it works. So if we're going to send that along to you, you're buying it, when is it that you're going to take over the title and risk of it? Well, the title and risk transfers upon the contract of sale. It has nothing to do with dollars. Okay? You and I make a deal. I sell you my computer mouse, $5. You say, I accept $5 for the computer mouse. We got ourselves a deal. There we go. There the title and risk transfers. Okay? Because the title and risk transfers upon the contract of sale. You don't have to pay me that money yet, but you still own the product. So rule number 1 says that if it's a specific identified good that we agreed on a price to, as soon as we make the contract, basically offer, acceptance, consideration, all those 3 components are there, then the transfer titles immediately. Now, same computer mouse, but there's no battery in it. It doesn't work. Okay, this is a wireless computer mouse I have here. There's no battery in it. You say to me, Paul, I will buy that computer mouse from you for $5. However, before I buy it, I want you to put a fresh battery in it. Okay, so the only difference between the first case and the second case is that in the first case, it was a deliverable product. It already had the battery in it. In the second case here, I'm selling you my mouse, but there's no battery in it. I say, well, I'm saying to you, you need to put a battery in it. And you say, no, I want you to put a battery in it to make it work before you send it to me. So effectively, the criteria was the deal will take place once you put a battery in it. Okay? So the work must be done to put the goods in a deliverable state. The moment I smack the battery into it and I tell you that I put a battery into it, the purchaser has to be notified. So I have to tell you, yeah, it's working now, brand new battery in it. The moment that has happened and you acknowledge, yeah, good, then the transfer has taken place, okay? Now, you say, well, what difference does the fact that the title? Well, if something came and smashed that mouse now and destroyed it, you still have to pay me $5 because the fact is you own the mouse, not me. Now, if I broke the mouse, that'd be different. But the fact of the matter, if something outside of either one of our control broke the mouse. Okay. The third rule is very similar to the second rule. There's not a large degree of difference. But the third rule said it's a specific good, in this case, a mouse. It must be weighed or measured to determine its price. Now, these are not weighed or measured to determine the price, but let's assume that it's blueberries. In this case, let's say I'm selling you some blueberries. We agree that the price is $10 a pound. Okay, $10 a pound. So you say to me, I want to buy a pound of blueberries off you, Paul, for $10. So we've got an offer, we've got acceptance, we've got the consideration. Good. So the thing is, though, I say to you, well, I got a lot of blueberries here. I need to weigh out a pound of blueberries, put them in a bag, and before I send them off to you. Oh, very good. Well, the very fact that we've agreed to pay $10 a pound means that we have the basis for a contract there. However, the critical thing is I need to weigh out a pound of blueberries first. And until I weigh out that pound of blueberries and alert you to the fact that I have them ready, we do not have a contract until that point in time. So the specific good must be weighed and measured to determine the price. Once I weigh them and measure them, or weigh them in the case of the blueberries, then and I alert you, then you now own the blueberries. So I say to you, well, you come pick them up. Now you wait 3 weeks to come and pick them up. They're no good anymore. Well, that's not my problem. You own them. And I told you they were ready. Okay, so that's effectively rule number 3. Now, measurement could be a case of it could be, you buy 10 feet of lumber, and I say, well, I got to cut off the lumber, that sort of thing. The 4th rule is someone has to approve the product. Okay, so specific goods taken on approval. In this case, I'm going to say that I'm a clothing store and I have pairs of pants. Okay, pairs of pants. And the problem is I don't have a dressing room. So you say to me, okay, what I'm going to do is I'm going to take them home and I'm going to try them on, and I'll let you know if I'm going to buy them or not. Okay, so that is some form of approval. I will give you the pants. You're going to take them home and try them on. And then you're going to alert me to the fact that, yeah, they're good, or you're going to bring them back and say, no, they're no good. So the thing is, you march the pants home, and the question is, who owns the pants? Well, if I'm selling you the pants, you haven't paid for them yet. You haven't indicated you're going to have them yet. All you said is you're going to try them on. So I still own the pants. Okay, so even though they're in your possession, I still own them. So when you come back to me and say, yeah, I have the pants, we got ourselves a deal. And you own the pants at that point in time. Okay. However, let's assume that you're silent. You take the pants home, and we know that price tag is on the pants of $10. Okay. So you take the pants home, you're going to try them on. I never hear from you again. And I think to myself, who owns the pants now? Who owns the pants? Because if you don't bring them back, can I enforce you to pay me? Well, the fact is, if enough time goes by, and you haven't indicated to me, you haven't come back to me and said, hey, I'm going to have the pants, or I'm not going to have the pants, I'm going to assume that you are accepting the pants. And in that case, they're yours. So what is a reasonable amount of time we're selling clothes? The court's really going to determine what a reasonable. There's no prescription there that says 2 days, 1 day, 12 hours, anything like that. But the fact of the matter is, if it what I would consider and you would consider and the court would consider a reasonable length of time. Listen, you're buying a pair of pants from me. You're going to take them home and try them on. I would think that it takes 5 minutes to try on a pair of pants. So I would think it shouldn't take you any more than 1 day to alert back to me that you're going to have them. Maybe a week, but certainly not 2 weeks. Certainly not 3 weeks, right? So we're really asking ourselves, how long is reasonable? Well, reasonable depends on the product. Oh, treating them, I almost forgot to mention, treating the goods as your own. Let's take the same scenario again. I'm in Buckinghamshire. I'm thinking of this, the community mart used to do this. You used to be able to go over to the mart and take clothes home and try it on and then bring it back. So let's assume that we're out, both of us are out for a walk, and I see you coming up the street with those pants on, and you're wearing them. Now, you haven't indicated to me whether you're going to buy them or not, but I saw you with the pants on. At the moment I see you with them on, I'm thinking to myself, they're yours now, because your actions have indicated as if you're treating them as your own. You wouldn't be out walking around the streets unless you agreed to buy them. So the consideration is that if you have purchased those pants and you are wearing them, even though you have not indicated to me that you're going to keep them, I've seen you with them. As far as I'm concerned, you're going to keep them. So this is an example where the transfer has title. Transfer has happened. The fifth one's a bit of a strange one, and that's where if the product hasn't already been made. Okay? You see, for example, you come down by my house and you see that I built this wonderful sign that says welcome. And I got it in the garage. I don't have it outdoors, but I got a wonderful sign that says welcome. Okay. And you say to me, I'd like a sign like that. And I said, well, I could build you one. Okay. So the question is, and we rated it as $25. It really is about $25 for the product there. So the price is set, $25. You say to me, I'd like to have one. I haven't built it yet. Who owns it? Well, what this does is it says when a good has not yet been made, or it has to be selected from, say, a sample or a floor model, the transfer of title that doesn't occur until the good is created, and that you are saying to me, yeah, I'll have it. Okay, so the title transfer to when the good has been created or unconditionally committed to the transaction with the assent of the buyer. So let's say, for example, you came and paid me $25 before I ever built it. That's the assent to the buyer. You're basically saying, yeah, we're good to go. Let's consider this. So once I make it, I alert you to its construction. At that point in time, the deal is done. Or if you hand me the money and I said I'll make it in a week, the deal is done. So there has to be this assent. What are my obligations? If I'm the one constructing something, well, my obligations to you as I sell something to you is that there is a condition of sale, meaning that sale will not happen unless this condition is met. That the good is going to be delivered to you in good title, meaning that I own it and can sell it. If I have a skidoo outside, my 12E land, okay, my 12E land. If I were to say to you, yeah, I'm going to sell you my 12E land for $500, and you say, great. But the thing is, it's my son's. It's not mine to sell. I can't really sell you that for $500. There's no deal if I don't own it. I can't sell something I don't own. So there is a condition there that says I have to have good title to be able to sell you that before you'll buy it. So if you find out that I never had title to it, there is no deal. So basically, the contract is null and void at that point in time. Can't be enforced. There is, so that's a condition. The condition means that there is no deal and there's no contract. The other two are warranties, meaning that I have to make it right if it's not right. Okay, it doesn't void the deal, but it means I got to make it right. When I sell you my 12A land, that the delivery would give you what's called quiet possession of the goods. No one's going to be phoning you up and saying that, hey, that's my machine. He wasn't supposed to sell that to you. Or that it's free from any, I'm going to call it problems. Quiet possession means that you can enjoy it for what you were told, what you were buying. You get what you were buying effectively without any problems associated with it. So I basically warrant that when I sell you something, it works and that it will work fine for you. Now, what is it that if it doesn't work? Well, I make it work. That's basically what I need to do. And there's a warranty too that the good is free from any encumbrance, so no one can say I have a lien on that. I have to make that right. If someone says that, I owe $500 on it, I sell it to you for $500, that doesn't void the deal. The fact is that I'm responsible for paying $500 to the owner. The Act also implies that the conditions for the good bought by description or sample meets what you get. Okay, let's assume that my 12E land, I send you a picture of it. Okay, I send you a picture of it and say, this is what you're buying. You get the machine, you say, that's not the machine that's in the picture. Okay, so I've sent you a picture. What you get doesn't match what was in the picture. Well, that's a condition of sale. And effectively, there is no contract if what I send you is different than what's in the picture. This is pretty commonsensical. If, for example, that You paid $500 for a machine that you thought was in immaculate condition. You get it, and it's just a piece of garbage. What repercussions do that have for you? Well, the fact of the matter is, the Sale of Goods Act says that if it looked in good shape in the picture, it has to look in good shape when you get it. So if I send it to you, you have a perfect right to refuse the delivery of it. Okay. And the Act implies conditions regarding fitness and quality of goods sold by description. So those blueberries, I described them as fresh ripe blueberries. I send you the blueberries and they're not fresh ripe. That's a condition. So there would be no contract in that particular case. And this also applies, the last two, this act implies condition related to fitness quality. This is basically, the good must be of merchantable quality, eatable, whatever you want to call it. It has to be fit. If it's not fit, then there is no deal. The good must be suitable for the purchase of which purchaser relies. I've told you that I'm selling blueberries and that they're in good shape, or 12 lamb is good shape. You get it? It's not, then effectively there is no deal. So all of these things relate to the idea that the product that you buy is a product that you get, and it has to match. There has to be a match there. If it's not a match, then the contract is null and void. Okay? Sellers may attempt to override implied conditions through limited warranties or exemption clauses. So in customer transactions, seller often prevented from contracting out by statute. Exemption clauses usually enforced in commercial transactions unless unfair. So what this does is sometimes the seller will try to force the buyer to pay. Well, in a consumer transaction, the seller will sometimes try to get someone else to do it, contract it out. Basically, we make an agreement to build a house and I get someone to try to do it for me. There could be some problems there. And an exemption clause, again, these create little bits of problems too, because they could be considered as unfair. So, we don't want to, the court won't uphold them. So these are all what are called implied terms. And when we think of the Sale of Goods Act, the Sale of Goods Act kind of puts in implied terms that may not be in the actual contract. So, if for example, the price is not clearly laid out there, well, if it's not clearly laid out, it throws the whole issue of consideration into if I'm selling you something, you're getting something, I'm selling something. Well, we have to make sure that there is consideration. But if there's a price implied, that has to be what is paid. So if no purchase price stated, a reasonable price is implied. If no date is stated on delivery, payment must be made in a reasonable time. So I say you can pay me later, but what is a reasonable time for later? And there gives some rights with regards to the seller too, in terms of, okay, we sold a product. So I sold you my 12 land. We didn't really set a price, but I have told you that machines just like it are selling for $500. Okay, so effectively there's an implied price. And I say to you, okay, I'll get it delivered next week. Next week is a period of 7 days. Sometime within next week works fine, but if it's 3 weeks time, that's not next week. So what are some of the recovery issues that if I'm selling it and I get worried that you're not going to pay me, if I have a good reason to believe that you're not going to fulfill your end of the contract, I can do a Latin term called stoppage in transit, which means stoppage in transit. If I got to put it on a truck to get from point A to point B, a courier or whatever, I can tell the courier, please stop shipment. So I can put shipment on stop. I'm allowed to do that if I suspect that there's something wrong, if you've broken that implied term. And there are provisions in the Bankruptcy or Insolvency Act that says, look, you're going to bankrupt. I know you're not going to pay me. I'm going to stop the sale. I'm not going to let you. I'm not going to make sure you don't get that before everything else.